Dear guests, friends, representatives of the diplomatic missions, esteemed guests, Your Excellencies, representatives of the diplomatic corps, friends, welcome to this presentation of the 6th annual monitoring report of the work of anti-corruption institutions. It's a report compiled by the Anti-Corruption Fund Foundation. Since the past 5 years, we're also focusing on the criminal justice system. We analyze the environment, the structure, but also concrete, specific cases handled by the prosecution. It's an honor to have you here with us, and with this, I give the floor to Mr. Boyko Stankushev, our director. He will say a few words, and then Mr. Pavel Usvatov, the director of the Rule of Law program for Southeastern Europe at the Konrad Adenauer Foundation, will have the floor. It is with their support and also with the support of the America for Bulgaria Foundation that we're able to function in Bulgaria and also to work on this report that we'll present to you today. Of course, I would like to thank the authors of the report. And we have the authors here with us today. And besides them, we also have 3 other panelists, Biljana Geurova-Vegerceger, the director of the Bulgarian Institute for Legal Initiatives. They're a long-standing Bulgarian organization, and they do follow institutional developments in Bulgaria. It's a great honor for us to have her here. We also have with us Dr. Atanas Slavov. He was a Minister of Justice formerly, and he was also an author of our report. The first 2 annual monitoring reports were authored by him. We also have here with us today Judge Vladislava Tsarigradska. She will give us the point of view within and the point of view concerning the issues in the criminal justice system within. Judge Tsarigradska is one of the few people who, and the few judges who have been vocal about the need to reform our system of criminal justice. And now, Mr. Stankushev, you have the floor. Thank you. Your Excellencies, representatives of the diplomatic corps in Bulgaria, colleagues, guests, friends. We also have guests who are friends, and even if we have guests who are opposed to us, they're also welcome here today. You heard from Laura, who is an excellent legal expert with the ACF, and she said that I will give a speech. Actually, I don't intend to give a speech. I gave speeches 4 years in a row, and the situation has been worsening over these 4 years in terms of corruption and conflict of interest in Bulgaria. Laura touched upon some of these issues, and she mentioned actually what the report is all about. So I'm not going to talk about the report or the issues in detail. I would like to say, however, the following. We have a very nice Bulgarian proverb, and it is very fitting to describe the absurd situation that we have in Bulgaria, the situation concerning the relationship between civic society and the justice as a function of the criminal justice system and the interests of Bulgarian individuals, because our interests are defended by the Constitution. And the proverb is, I'm not sure how it will be interpreted, that the dog keeps on wagging, but nothing really changes. And I believe this proverb is very fitting. It is not just the Anti-Corruption Fund Foundation. It is not other or just the well-established representatives of the civic sector. But in terms of this, but we also have voices from within the media saying corruption is reaching a critical point. The situation is unbearable. Surely the people behind the grand corruption and the biggest corruption schemes are the leaders of some of the major political parties. So we have the feeling that we keep on writing reports, but actually nothing changes on the ground. The small change that we have seen is that we do receive comments from some of our colleagues, but even our colleagues are a little bit scared to voice their opinion openly. And we receive more vocal support from the representatives of the diplomatic corps. So, in terms of these corruption schemes that we have in Bulgaria, they're very complex and they penetrate to the very highest echelons of government, in the executive branch, in the judiciary, in the secret services. And we oftentimes identify these scandals, but in terms of the institutional response, we see nothing. We see, for example, the public prosecution or other public bodies reporting on their anti-corruption success. But those reports are really inadequate. We see inflated figures, we see mentions of people being prosecuted, but usually we have some very low-ranking officials who have been investigated. Of course, corruption in Bulgaria is not a new phenomenon. We had corruption during the former communist regime. But what we have seen, especially through our latest investigations, for example, the 8 dwarfs, we see that it's evident that corruption has reached high-level magistrates, ministers of interior, the highest levels of government. So in conclusion, I will say that despite the fact that the picture is really worrisome, and you'll hear more about this from our panelists, I still remain an optimist. And I base my optimism on my empirical observations, which show me that still in our society we see more openness, more willingness to speak publicly against corruption. We see more solidarity. And I hope that this kind of energy, maybe in 4 or 5 reports, will change the picture, and I will be more optimistic in a few years' time. Thank you for being with us here today.
Thank you, Boyko, for this optimistic end to your speech. And with that, I'd like to give the floor to Mr. Pavel Osvatov.
Thank you very much. Thank you, Boyko. I want to link up to what you said. There is several, like a kind of a joke about lemons. I will transfer it to ice. So if you get ice and feel cold, just make a cocktail or something with it. And hopefully in a few years we will be here and we'll talk about this from a different perspective. Excellencies, dear colleagues and friends, I welcome you here too. Thank you very much for joining today. As every year, I think it's one of the most important meetings and conferences on that topic. And this report is actually a very special issue, not only in Bulgaria. Most countries don't have such reports, and also reports of such quality. I'm very thankful to ACF team for what you are doing, and also, of course, to everyone who is supporting you, to the media, which is very important, what you also mentioned. Most of the corruption issues are covered up not by prosecutors or police, they're covered up by media. So the investigative journalists find out about the things, and then the public authorities can pick on it and continue investigations. And just one thing, I don't want to talk for too long because we have a really interesting panel here. I'm super happy that you all came. Thank you very much. And the stability of the government is actually crucial for improvements in the field we're talking about. And I think, Atanas, you will probably say something about it later, but being in office just for 1 year, it's just not enough time to do anything. And I hope that we will see as soon as possible a stable government. We all are looking forward what will happen in the next months or in the fall. But I wish Bulgaria a stable government, and in the end, probably it doesn't matter that much which government it will be. There should just be stability and a Minister of Justice and a Minister of Interior who will do their work and do their job and do it continuously. So thank you very much. I'm very much looking forward to first to the results and to the presentation of the study that I already know, but for you it will be very interesting, I think, and to the discussion, of course, too. Thanks a lot, and have fun, everyone.
Thank you, Pavel. Now we continue with the presentation of the first part of the report. Firstly, let me draw your attention to the title. Each year we try to communicate the main themes through the title and to come up with a title that really summarizes our conclusions. Now I give the floor to our colleague Andrey Yankulov. So he will be able to tell us what froze in the criminal justice system. Were there points where the ice was thawing, for example? Have there been any changes, and how he sees the situation and what happened in 2023? Hello to all our guests. As my colleagues said, this is the 6th consecutive report, and for the 5th time, we're looking at specific cases related to the criminal cases related to prosecution investigations. So with this year's report, we have 57 cases altogether. And this is a representative sample concerning the biggest corruption cases in Bulgaria for the last decade. The first report, which we issued 5 years ago, it looked at some cases that had been ongoing. So overall, when we look at these 57 cases, they show you what the trends have been over a considerable period of time, a decade. And these 57 cases are the most significant high-level corruption cases. Maybe we skipped one or two or missed one or two, but actually this is a representative sample. What we have observed, unfortunately, our conclusions haven't changed. They won't change in the future, despite the changes in the institutional environment, if indeed such changes take place. Why is this so? Because everybody knows that a criminal investigation takes time, and litigation also takes time. So you need a number of years, even if changes happened today, legislative changes and institutional changes happened today, you need a number of years to actually see the results. What have we seen so far in terms of results? Actually, zero. It's not possible to state this any other way. We cannot make this conclusion to sound better or to reflect more positively on the institutions being monitored. Because out of those 57 cases, 36 have been completed already. And of those 36, we have 4 final convictions. 15 cases, we have final acquittals. And then we have 17 cases that were terminated by the prosecutors themselves. So these cases did not even reach the court stage. Out of these 4 final convictions, we only have 1 effective conviction. It means only 1 person who is actually in prison right now because of corruption. This is the well-known case. It was a flagship case of the now defunct specialized prosecution, and it involved the former mayor of the Mladus district in Sofia, Desislava Ivancheva. And now it's time to say that probably with regards to this case, it's probably time to show some mercy to this person. It's a person who has been convicted for the first time, no violence has been committed, and it concerns the mother of a young child. So she has served already a large chunk of her prison sentence, so perhaps she should be considered for a pardon, because even the mechanism for issuing pardons has some deficits. Let's say it that in cities where there are vacancies in the prisons, we see actually that the local institutions are unwilling to facilitate pardons, even if this sounds strange. It does sound strange on the face of it, but actually there's also a logic to it. Going back to the report, what has remained unchanged since our first study is the following. In terms of the investigations and concerning high-level corruption, these investigations don't target high-level corruption. Typically, prosecutors are not systematic when they investigate such cases. They usually are more focused on the media attention whenever they do decide to open such inquiries and investigations. And usually these cases are closed or are terminated without any motivation or grounds. And if there is anything that we can, or any conclusion that we can draw from the data from this year, we have an increase in the number of cases, in the number of investigations that are terminated by the prosecutors themselves. In a way, this is a positive development, because if it's obvious that no crime has been committed, it's better that these proceedings are terminated by the prosecution rather than reaching the court stage. This would further harm the individuals who are targeted by these investigations, and also it saves public resources. especially since many of these investigations are unfounded. So this is the picture. And the key question is why? Why is the picture looking like this? Well, we need to state very clearly that the institutions who have been tasked with dealing and counteracting high-level corruption are paper tigers. They seem to have rules. There is a set of rules that have been outlined. Many of these rules meet the European requirements for institutions of this kind, but this is just a facade. Inside, these structures are hollow. These structures do not have any concrete substance. And the actual work that these institutions should be doing, well, they're not doing it. Why is this so? We have many examples since the past years, but I will just give you really the most telling example from last year. It was a really telling example showing us how the Supreme Judicial Council operates. On paper, this is supposed to be an independent institution. It has been established as an independent institution with the creation of the modern-day constitution in 1991. There were some discussions how the quotas between prosecutors and judges and other members of the Supreme Judicial Council should be allocated. There were some other discussions, but these are actually technical details. The rationale the rationale for the existence of this public body of the Supreme Judicial System is that, at least on paper, as per the European rules, there should be an independent body. A body comprised of magistrates, be it magistrates elected by parliament or magistrates elected by their colleagues, to oversee. And this is supposedly a more independent body compared to a situation where it's only the executive appointing the members of the Supreme Judicial Council. So what did we see last year? There were all sorts of protests by political parties, by the civic society. So what happened is the Supreme Judicial Council, which elected Ivan Geshev, the former prosecutor general, and they were defending him throughout all sorts of scandals. And all of a sudden, they shifted their allegiance. So there was just very quickly, after certain political actors demonstrated they no longer support Ivan Geshev, the Supreme Judicial Council, comprised of members who had been loyal to Ivan Geshev, all of a sudden changed their mind and elected another prosecutor general, Borislav Sarafov. So all of a sudden, a person who appeared omnipotent was removed from his post immediately on formalistic grounds and by the same people who had appointed him and who had supported him. This is how easy it was. So this is yet another telling example which shows you why the state that the conditions in Bulgaria that we have right now are as they are. Well, because the institutions are just paper tigers, the actual decisions are taken elsewhere by people that we don't know, that we're not aware of. And actually, some confirmation of this was evident in a leaked conversation between the former prosecutor general and several of his colleagues. And why did this shift happen? And why was Ivan Geshev replaced? This was purely based on personal characteristics. And we saw in this period of Ivan Geshev, trying to remain on his post. There was a short period that he was trying to hold on to his power, although he was no longer agreeable to the unknown forces. He all of a sudden tried to activate investigations that the prosecution had started, but nobody knew what actions exactly they had been taking. And why? But unfortunately, these investigations ended with no results. And this was also because there is no cooperation between the public prosecution and other institutions.
Now that the summer had passed, the new prosecutor general and the institution under him completely forgot about the topic of corruption among those in power. That is, until the end of last year, and I mean literally forgot. All the cases that had been handled by the predecessor of the current prosecutor general were ceased to develop just because the situation needed to settle down. And once the political majority that caused the former prosecutor general to leave his position started to collapse, that's when we saw other cases for criminal prosecution that did not aim at securing convictions, but rather pursuing other objectives that don't have anything to do with those set out in the Code of Criminal Procedure or the Criminal Code. The idea is to throw shade at someone. That's the reason why there are certain criminal proceedings initiated in specific cases and others are kept under wraps because the secrecy of an investigation, they claim, needs to be protected and nothing can stand above that. So what is the solution to this predicament that we're facing? To tell you the truth, as time goes on, I grow more and more convinced of the following. These problems can't be solved by drafting a checklist and saying, oh, we've amended this act, or we passed this act, we increased the number of judges in the judges' chamber of the Supreme Judicial Council from 6 to 8, etc. This in itself does not do much. Because yes, the rules are followed, but they are followed only in terms of the letter of the law. the functioning of the anti-corruption institutions shows this. And when it is only the letter of the law that is followed, the rules themselves cannot be very effective, no matter how in compliance they are with the requisite standards, no matter how many fanfares there are about the adoption of a specific act. We had an example of that in the face of the a mechanism for investigation of the Prosecutor General. We waited for over a decade for this mechanism to be introduced. There was a conviction against Bulgaria in the court in Strasbourg. Of course, there are some deficiencies that this is plagued by. This is typical of any such situation. But the second this mechanism had to be implemented, we observed how this implementation can easily be hindered. Last summer, we had to spend months, as from the point at which the judge that had to be appointed as a prosecutor investigating the Prosecutor General. And from this point up till their actual, the actual start of their work, months took place. Supposedly there were specific provisions in the law that had not been drafted well. Then the Supreme Judicial Council decided that they weren't going to approve that immediately. Then in December, the lady took office. Then there was no desk for her to sit at. Then there had to be specific rules about how exactly all the logistics is supposed to take place. In any case, she took office in December. And of course, this delay had quite a lot of importance, specifically when it comes to specific criminal proceedings that had been launched as part of a campaign by the former Prosecutor General or under his orders anyway. The idea was to find dirt on his deputy and the current Prosecutor General, Mr. Borislav Sarafov. So the new investigating prosecutor had to wait months to take office, and evidence ended up being concealed. Evidence pointing to criminal activity on the part of the current Prosecutor General or other magistrates. So yes, there was a lot of chaos, and this person had to wait until they stepped into office. The legal provisions were implemented but not in line with their purpose and meaning. This led to the possible compromising of the evidence, and this, of course, was in the interest of the person against whom this evidence will have been collected, namely the current Prosecutor General. So yes, we have a mechanism. Yes, there are restrictions in the Constitution. Yes, there are minuses that go with that. Yes, it is flawed. But this was a mechanism to investigate a person holding a lot of power. And this example showed us that in case someone decides not to implement this, they can find various ways to hinder the implementation. So we need basic good faith when such legal institutions are implemented. They do look good on paper. So there is no silver bullet. And it will not we won't be able to solve these problems by kneeling at the altar of amendments to the legislation. Not everything can be solved by those. I ended up giving a rambling talk. I do apologize. I meant for it to be brief. In any case, I should point out that you shouldn't expect too great a change vis-a-vis the status quo in this edition. Probably there won't be in the editions to come. Thank you. Thank you very much, Andrey. Taking into consideration that the only new case that was added in the criminal prosecution of high-level corruption section, specifically as regards the central level of power, is about Borislav Sarafov, the current prosecutor general, and in this sense we need to delve into greater detail in it for those of us in our audience who may not be quite aware of that case. Time and time again we have said that unlawful disposal of evidence gathered is a serious issue. I believe this is quite clear to all legal professionals, and it should be made clear to our wider audience why this is important. There is no hope of a successful resolution to a case unless the actual evidence that has been collected is used. In this particular case, evidence was gathered, but this evidence was never published. Its content was never made public knowledge. In any case, this evidence gathered made it to the Sofia City Prosecution Office. It ended up in the hands of prosecutors. Witnesses had, they ended up in the hands of prosecutors that have been implicated as being part of Petru Everutu's scheme. You know that there was a photo of him having a handshake with Borislav Sarafov in the Eight Dwarfs restaurant. All of this was forgotten. The witness testimony to links between these two persons was also disregarded. And it turned out that all of this information concerning property owned by Petru Everutu ended up in the Sofia City Prosecution Office. And of course, both legislatively and in technical terms, this is under the direct control of the Prosecutor General. The Supreme Court of Cassation never examined the evidence, and there was no way to see if the evidence that made it to the Sofia City Prosecution Office was the same evidence that Judge Taleva, the investigating prosecutor, that is the person tasked with investigating the Prosecutor General, got that same evidence. So with that, I'd like to give the floor to my colleague Daniela Peneva. She will be sharing observations on the functioning of the Anti-Corruption Commission. There are lots of problems, particularly when it comes to conflicts of interest. Later on, we'll give you a bird's eye view of the work of the Commission, the other strand, that is.
Thank you all. With regards to the Anti-Corruption Commission, the state of affairs is not much different than what Andrey said regarding the public prosecution. Before I present the results of our analysis, which focuses on the mechanisms of ascertaining conflict of interest by the CAFIAP, the Commission for Anti-Corruption and Forfeiture of the Illegally Acquired Property. This commission was then inherited by a new commission for the counteracting of corruption. Before we go on to the analytical part, I would like to say a few words about the legislative changes that took place pertaining to these public bodies. Last year, a new anti-corruption law was passed, and this was a positive step in terms of increasing the effectiveness of the efforts to counteract high-level corruption. Andrey already mentioned that many of these laws and adopting laws, just merely legislative steps, are not a solution per se. Of course, they are an important part of the solution and should be mentioned. And also, when we review these laws and the discrepancies related to the picture that we have on the ground, then we see how effective the anti-corruption institutions are. Let's go back to the new anti-corruption law now. What it did is it separated this big mega commission, the CAFIAP, into two: the Commission for the Counteracting of Corruption and the Commission for the Forfeiture of Illegally Acquired Property. So the Commission for the Counteracting of Corruption, of course, will look into conflicts of interest, will monitor the declarations of assets by public officials, and will have several other functions. Importantly, functions to investigate corruption crimes. So the people who were in charge of the old CAFIAP are now transferred to the Commission for the Counteracting of Corruption. Supposedly, this is until new members of this commission and the other commission on the forfeiture of illegally acquired property are elected. According to the law, the election process is the responsibility of an electoral commission. This commission should shortlist candidates. It should come up with a report. The report should be reviewed by the National Assembly, and then the National Assembly, with a qualified majority, should elect the independent leadership of the new commission. The 49th National Assembly was unable to elect the leadership of these new bodies and of the new Commission for the Counteracting of Corruption. So basically, the old leadership remained. And this is a significant fact because these persons were elected in 2018 by the parliamentary majority, by the GERB party, and they continue to carry out their functions as they always have. We should also mention that in March 2022, Sutir Tsatserov, the chairperson of the CAFIAP, resigned. And since then, CAFIAP does not have a chairperson. Its leadership is consisting of 4 members. However, despite this, it seems they can take decisions easily. At the end of last year, the deputy chairperson of the commission, Anton Slavchev, participated in a procedure to be elected as prosecutor in the Sofia City Prosecutor's Office, but he is still with the Commission for the Counteracting of Corruption at present. So considering all of what I mentioned previously, we can perhaps figure out why there are no visible results in these 2 public bodies' work. Firstly, we will review the work of the CAFIAP, the old CAFIAP, and then we will focus on the Commission for the Counteracting of Corruption. In terms of the results of their work, there seems to be little differences. Both bodies are ineffective. In 2023, 101 cases were reviewed, cases pertaining to conflict of interests, and of those more than 100 cases, in only 11, specific evidence of conflict of interest was uncovered. These cases don't concern officials at the highest levels of government. Typically, these are low-ranking to medium-ranking officials. I will present and I will give you three reasons why the results are show a lack of effectiveness. Firstly, we see a lack of will to target corruption, and also, of course, there's no leadership, new leadership in charge of this new commission. It's important to mention that the commission never investigates suspicions of corruption out of its own accord. It only reviews reports and tip-offs that it has received. So this commission has been created to make sure that public servants act in good faith and observe the law. And of course, the mechanisms to investigate and sanction conflict of interest is important because it prevents the officials from abusing their power. Very often these are complex investigations. It's quite difficult to investigate them and to collect evidence. And this specific mechanism that has been created to look at conflict of interests aims to focus on this kind of crime, to make the countering of these kinds of crime more effective, and to have a preventive measure, a preventive effect. The second reason why we're seeing a lack of results has to do with the formalism employed by the Commission when it reviews particular cases. When I've been reading their decisions pertaining to particular cases, I really had the impression that they were trying to make sure to make sure people are looking at the evidence that shows that people are innocent, rather than look at evidence that points to them being guilty. We also see that they're quite vague in their interpretation of the law and taking advantage of loopholes to issue decisions that there are no conflict of interests in particular cases. So, of course, and there is a vagueness, particularly in the Bulgarian law, concerning conflict of interest. So, if legislative measures are taken to clarify this vagueness, perhaps then the effectiveness of investigations will also increase. And now I would like to mention a few details regarding this notion of conflicts of interests and also connected parties. The definition in our Bulgarian law is very limited. And for example, if you're talking about an official and their best man, they are not considered connected parties as per Bulgarian law and as per the way in which the Commission also interprets the Bulgarian law. Another case concerns Kirill Petkov, the political leader. He was being investigated by the Commission. And he was being investigated back when he was a part of the He was part of the caretaker government. And it was pertaining to his Canadian citizenship. There was an argument whether he still held his Canadian passport while he was also a minister in the caretaker government. So the case was reviewed in a formalistic manner by the Commission, and they really did not review the merits of the case. Thirdly, when it comes to the lack of effectiveness of these investigations concerning conflict of interest, there is a lack of mechanisms to actually appeal against the decisions of the Commission. And this, for example, if a person has been found guilty of conflict of interests, there are provisions allowing them to challenge the decision. But this is not the case when persons have been found not guilty. Prosecution, for example, the prosecution cannot challenge such decisions.
We decided to ask the prosecution service the following. We asked a question specifically to the Sofia City Prosecution Office. It has competence to appeal against decisions acquitting high officials in the local authority. And we asked how many objections to how many appeals rather, it had filed against such decisions by the Commission for conflict of interest. In the year 2023, and apparently there were no appeals of this sort because the decisions were handed down in keeping with the legal requirements. Allow me now to illustrate a case in which both the prosecution service and the Commission see no problems to what they're doing. I'll cite a case that has already been mentioned in the report where none of the institutions sees a problem, specifically the decision against Cornelia Ninova as the Ministry of Economy and Industry, and as we had the Chief of Staff for her, Eli Peneva. That's 2021 until August 2022. There were state-owned companies that are under the Ministry of Economy and Industry. These companies concluded lots of contracts having to do with assistance in specific cases and subscription contracts. One of these was concluded with a legal service company. The manager of this company is the son of Ms. Peneva. This is to the amount of 400,000 lev. According to the Commission, the lady, that's the Chief of Staff, Ms. Peneva, did not or use any sort of authority. It had no way to influence the Minister of Economy. Ms. Linova, for her part, the minister at the time, was not related neither politically nor economically to the people in the lawyer's firm, and therefore there were no actual pieces of evidence pointing to conflict of interest. When it comes to the expending of public funds, such arguments are altogether insufficient. That's because there was no analysis for whether there was actually a need to conclude these contracts in the first place, whether they had to be concluded at such haste, what the average market prices for such services were. Essentially, there was no analysis as to whether public interest has been breached, whether there might have been some sort of agreement between these various persons in order to that leads to unjust enrichment of the company, for instance. So the police and the prosecution, rather not the police, but the commission and the prosecution, did not even consider the actual option of there being a deal that is not favorable to the state-owned enterprises or some other criminal activity going on. I think that this case is a case in point. Thank you. Thank you, Dani. As it turns out, the Commission, more than ever, spent 2023 being a commission for the lack of ascertainment of conflict of interest. As we said, there were 101 cases it examined, 132 were examined and 122 were said to not have conflict of interest. 11 were said to have conflict of interest. So this commission is possessed of a huge budget, and one wonders what the political use of an institution that will only work when seized of something by citizens is. After all, we're talking about the work of the executive. As was already mentioned, work in this field of conflict of interest is particularly important. In many cases, there is potential conflict of interest and actual crime that was committed. This is why the work of the Commission for ascertaining conflict of interest was part of our very first report and has continued. This has continued ever since. This, mind you, is the most transparent of all the institutions handled. The Commission publishes reports on conflict of interest with a lot of frequency. But there is another strand that has to do with the forfeiture of illegally acquired property. And unfortunately, this has been concealed, be it behind an iron curtain or a curtain of black velvet, you name it. And this is obscured in the annual report of the Commission. Since 2022, for over 2 years now, we have been investing a lot of effort in getting access to the decisions of this Commission pertaining to bringing forfeiture proceedings, that is, decisions to lodge application and thus to transfer a case to the court. Now, the administrative court in the city of Sofia held that this information had to be public knowledge. That is, it is governed by the Public Access to Public Information Act. This decision was handed down in November of 2022, and up till this point, the information has not been given to us. The Commission suspended the proceedings, saying that it has objected to this on the grounds of the decision of the administrative courts of being null and void. So again, the court needs to examine whether it is null and void at this point. Unfortunately, here, courts also have a part to play. Specifically, the Supreme Administrative Court. It stated that the Commission needed to stay the access to public information proceedings, precisely because the Commission had objected to the decision of the Administrative Court on the grounds of it being null and void. And of course, this opens the gates to arbitrariness on the part of administrative authorities if this practice is taken up by all sorts of administrative authorities under the Access to Public Information Act. If such objections on the grounds of a decision being null and void keep being lodged, and this leads to the suspension of proceedings pending before them, this could lead to a breach of the European Convention of Human Rights. Clearly, there are mechanisms that allow for such loopholes. This is precisely why last year we seized the European Court of Human Rights with an application. It was admitted to the hearing stage, but it is currently pending. The application has to do with the following: that Bulgarian authorities, specifically the Anti-Corruption Commission and administrative courts, as well as other Bulgarian authorities, have allowed for such remedies that make pointless the provisions on access to public information. The fact that this application was admitted for hearing shows that the ECHR does accord quite a lot of importance to such cases pertaining to access to public information. When it comes to the activities of the forfeiture strand of the Commission's activities, as presented in the 2022 report, we can see that the results are quite worrisome. The Commission stated that in the year 2023, and the interpreter corrects earlier it was 2023, that it seized property to the amount of 12 million or something, and the quantum of the applications that had been dismissed was 1.7 billion left. So we have 12 million that it had secured and 1.7 billion that it hasn't. And they tried to make an excuse for these poor results. They stated that there were cases, that these cases whose quantum is 1.7 billion are due to interpretive decision number 4 of the General Meeting of the Civil Chamber of the Supreme Judicial Council. According to this decision, property that is not in evidence as at the end of the period covered by a check, property that was generated, of course, at the start of the period covered by the Commission, but again, that isn't in evidence as at the end of the check, cannot be forfeited precisely because it is not in evidence, because it isn't there. And this is the decision that the Commission cites as the reason for why it had lost suits whose quantum amounts to 1.7 billion. Of course, one would wonder what the practical use is to have cases to seize property that doesn't really exist. This is an issue that has long been cited among experts as a criticism towards the work of the Commission. We also stated this in our previous presentation of the previous report. These activities essentially have to do with the forfeiture of assets that aren't there, and this breaches the minimum standards having to do with the protection of the persons against whom such proceedings are brought. Another point having to do with forfeiture that is not clearly seen in case law just yet has to do with the decision of the ECHR. The decision handed down states that there needs to be a connection between the proceeds of crime and the property that is to be forfeited. The way that this is proven does not need to meet the standards of criminal proceedings, but the court does stipulate that there needs to be indications of a link between the proceeds of crime and the property to be forfeited. And this is why the ECHR identified a few key shortcomings of forfeiture proceedings. Experts on forfeiture in Bulgaria, including us, by the way, have also been citing these for some time. In the first place, we have the arbitrariness of these proceedings, that is, the fact that they may not be very related to criminal proceedings to begin with. In practical terms, this means that it's sufficient for someone to be accused of any one of a broad range of crimes for them to have a check launched against them. The criminal proceedings may be suspended, they may be terminated even, they may be discontinued, but the forfeiture proceedings will keep running regardless. Another matter having to do with the start of forfeiture proceedings and their continuation regardless of whether criminal proceedings are ongoing or terminated has to do with the proof of the property and how it fluctuated in the course of 10 years preceding the end of the check. The lack of evidence when it comes to the lack of evidence when it comes to quantums that are under 5,000 lev and others. Citing all of these, the ECHR states that in order to ensure the minimum safeguards of the right to own property, which is highly important in these proceedings, it's important for courts to aim to establish at least some relationship between the offending act, the crime that is, and the property that has been acquired. And just a few words on another strand of the work of the Commission having to do with the public registry. This is again a strand that is characterized by significant formalism. We're talking about, for instance, the processing of property declarations. The similar formalism plagues the work of the inspection service of the Supreme Judicial Council when it comes to the property of magistrates. There is no desire to cross-check whether the income that this person has gained corresponds to the property that they owned. They just check in the registers that are made public. Essentially, this makes the check of the declarations completely useless. Essentially, they're just ticking boxes.
So what this means is that in cases where no asset declaration has been filed, or cases where there are irregularities in the asset declaration, essentially no action is taken. This is again another loophole in the work of this commission. As we already mentioned, the leadership of the commission, a new leadership should have been elected for this commission, the Commission for the Counteracting of Corruption. However, this did not happen. The appointment procedure did not start at all. According to the Constitution, the leadership of many public bodies had to be changed, public bodies with oversight functions. And having said that, I would like to give the floor to Biljana Georova-Vegerceder. She's the director of the Bulgarian Institute for Legal Initiatives, one of the most established organizations which analyze public appointments. So I would like to ask her about her view on these issues. We even co-signed an open letter to the National Assembly calling on them to ensure that public bodies with oversight functions do elect new leadership, and they do elect the new leadership as per the new amendments to the Constitution. However, this did not happen. Why do you believe it's important to have independent leadership in these public bodies? Thank you, Laura. I was supposed to speak after Dr. Slavov, but I'm happy to take the floor now, and I can go on and on and on about this topic. First of all, I'd like to congratulate the team, the ACF team, because of their work on the report. It's an in-depth report. And we, as a watchdog organization, we know how much work and how much creativity it takes to actually compile such a report, to obtain the relevant information by public institutions. And this is information that actually should be easily available and should be public. I want to also commend you on the title, this title about freezing point. Yes, this is a very telling, very precise description of the situation. And in terms of the effort to counteract corruption, this tendency of freezing, we saw this in 2023 already with the adoption of the new anti-corruption law. And what do I mean by this? Actually, the very adoption of this new law just united four existing institutions into a new regime, but no analysis had been carried out of these institutions' previous work, of their objectives. The impact assessment was really formalistic. The budgetary assessments were really very questionable as well. And the motives, the grounds provided were basically that, well, this is just what Brussels requires. So since 2018, it's not just about us being in a freezing point, really, in Bulgaria. It's about an ice age in terms of the efforts to counteract corruption. Unfortunately, this is also a trend that continues to grow and won't go away. Our organization also analyzes the work of the justice system, and we also monitor appointments in the justice system. We started with this. We created the methodology, and then we applied it to appointments by the National Assembly. These appointments of leaders in the various public bodies within the executive. These appointments are very important. We've been monitoring all these appointments for more than 10 years. And we've analyzed the work of all the national assemblies from the 42nd until the current National Assembly. And what we see is that there are violations and there is an unwillingness to take seriously the mandates for these public bodies. Actually, the refusal to quickly appoint new leadership and to leave these public bodies kind of hanging is a type of corruption. It's possible to even say that the situation right now in Bulgaria amounts to strategic corruption. It's a new level from the endemic corruption to state capture, and now we're talking about a higher level, the highest level, which is strategic corruption. And here I'm talking about a process that not just entails the abuse of power. It's also a process that involves political calculations and not just institutional calculations. as to how to manipulate certain institutions within the judicial branch of government or the executive branch of government in the long run. And the effects of this process are really far-reaching. It doesn't just mean that certain parts of our government are captured. It means they're designed to stay this way. As the Luxembourg court has said, it's about pre-calculated submission. It's about calculating and strategizing how to keep this submission. So, by violating these principles of the mandate, the people in power, the national assemblies, ensure that the possible leaders, the would-be leaders, would be even more willing to succumb to pressure. I believe Sadhya Tsarigradska will agree with me that corrupt actors know that if you say yes to a corrupt proposal once, and then they know that this is it. You allow certain irregularities to happen, and if you say no, then there are also consequences for you and for your ability to serve in certain institutions. So, in terms of this situation of strategic corruption, it means a bigger collective effort should be engaged in actually remedying the situation, in changing the situation. Now let me go back to these appointments, the appointments of regulatory public bodies. One key appointment that we were all looking forward to with the amendments with the new law last year and was the creation of the Commission for the Counteracting of Corruption and the appointment of the leadership. As you know, the deadline for the election of the leadership expired in January this year. So again, we are again in a situation of vacuum. No rules have been adopted for the work of this new body. Actually, there was a motion that was about to be tabled for these rules, but they were not passed by the Assembly. And of course, it was not possible to form this new commission. It was not possible to even have a public debate as to what kinds of individuals should have these positions, these key positions. And in terms of the Commission for the Countering of Corruption, it was supposed to have a membership consisting of 3 persons, and they were supposed to rotate. This public debate never happened. And this all happened while the National Assembly was working. Politicians kept on saying, well, it's not possible to organize these procedures because of the short lifespans of the national assemblies and the lack of political stability. But actually, the examples that I gave you and the violations that we have observed throughout the years concern the refusal of working legislatures to actually elect the leadership of key regulatory bodies and key anti-corruption bodies, and bodies which were supposed to implement key anti-corruption policies. At the same time, what we have noticed is that when there is political will, to dispose of somebody, as happened with the former Prosecutor General Ivan Geshev. The system is very quick to act, including the National Assembly. They are very quick to actually remove persons who are trying to manage the institutions under their leadership in an independent manner. Let me give you one example of the chairperson, the former chairperson of the National Audit Office. This was the person that was removed at a record speed by the National Assembly, and it took less than 24 hours to terminate his appointment. And following his removal, even though actually the Constitutional Court twice decided and twice stated that this removal was unconstitutional, the MPs used all kinds of technicalities to obstruct the decision and to restore this person to his post. These are the kinds of examples that point to this strategic corruption that we have in Bulgaria. We are a parliamentary republic. And when we see that the National Assembly refuses to abide by the decision of the Constitutional Court, then me personally, as a citizen, as a lawyer, I start questioning, well, what will happen to all of us? And how will other individuals in Bulgaria behave when the highest levels of government are showing that there are no standards and they do not observe any kinds of standards? The case regarding the National Audit Office is so emblematic that it actually has its own life within the public administration. Officials joke with each other, saying, "Oh, be careful! You don't want what happened with the director of the National Audit Office happen to you." So this failure to replace leaders and to replace the directors of these key bodies promptly also is reflected in various other steps. So, for example, it took the 43rd National Assembly 143 days to elect the chairperson of the Commission for the Protection of Competition. And then this last National Assembly, they took 1 day to elect the chairperson of the health insurance service. So it's 143 days versus 1 day in the 49th National Assembly. So you see the situation, how the situation changed between the 42nd National Assembly and the 49th. So in terms of how these election procedures are organized, we see that the quality is diminishing. There are no safeguards, but also in terms of the parliamentary debate, we're seeing a real decline. And this serves as a turnoff for experts, for proven experts, to express willingness to be nominated and to take up these leadership positions. And this will impact the selection that we have. And it seems the political class is unwilling to have institutions, key public institutions, being governed by independent professional experts.
I'm citing this because I was listening to him as I was preparing for today's discussion. This is what is handed down from the top. So what else can we expect? What can we expect from the people who are appointed by those in power to those leadership positions? So Mr. Borisov said that. We have, at this point, 80 plus people who are currently working in acting capacity. That is, they are not they're not serving their own term. These are supposed to be the crème de la crème. That is, the people who are supposed to know what they're doing. Now, on the 18th of June, the top 3 of those 80 people on this ranking included, for instance, people from the Commission for dossiers. Then this commission has been working in these people have been working in acting capacity for 7 years. That is, their mandate has expired for this long. You might say, oh, this isn't that important an institution, but then you would be confronted with the Commission for the Protection of Personal Data. This is a key institution, ladies and gentlemen. Indeed, this is the authority that is supposed to ensure the protection of whistleblowers. And you know that whistleblower protection is particularly important to combating corruption. This commission has been working for 5 years in acting capacity. So 5 years it has spent with its term in office expired. So how can you expect the members of this commission that may not be too precise in their work according to indications? How can we expect this institution to function well? There is a register that in which it keeps all the signals from whistleblowers, and it's supposed to only communicate one way and not disseminate information on whistleblowers. And then in the top 3, we have the inspection service with the Supreme Council for the Judiciary. It has a specific term in office, but for 5 years, 2 months, and 3 days, it has been working past the expiry of its term in office. I won't be talking about the adequacy of their work. Judge Tsagagatska has experience when it comes to that. But this is the authority that, under the Constitution and under special legislation, is supposed to protect magistrates. How can it be expected to do that when it's been working outside its term of office for 5 years? I have doubts as to whether it can work well or not. Many of the inspectors are not even there. One of them left the system. Another colleagues left of their own accord. So basically, the chief inspector will be the only one left standing at the end of the day. The Supreme Judicial Council, of course, makes it into the ranking itself, but I don't want to take too much time. I'm trying to outline the general patterns. That's why I cited the main 3, which are not less important than the Supreme Judicial Council at all. I very much liked what Andrey mentioned as he was presenting his part. He said that a lot of the infrastructure, rather the work in Bulgaria when it comes to combating corruption, is done in campaign fashion. They depend on which way the wind blows during the elections, who will make it to parliament, etc., etc. So this is a constant political, economic campaign, if you will, branded as combating corruption. And this is what the ACF's current report shows. We don't have a sustainable policy to combat corruption. We have this wonderful strategy, but it's not implemented. I'm saying wonderful, but that's because I take into account the fact that the civic sector was included in its discussion and many of its suggestions were incorporated in it. But unfortunately, the strategy is not being implemented. It never really materializes. And why is that? Because everything works in campaign fashion. It was adopted in 2021. It was supposed to cover 2021 to 2027. That was the end of Gerb's reign in power. Unfortunately, after the strategy was adopted, it never started to be implemented. Why am I saying all this? Why is it important for us to show civil initiative, to require that the various terms in offices and institutions are adhered to? That's because these institutions are also subordinate to someone in some form or fashion, precisely because the terms in office are not taken into account. And the national legislator states that keeping to these terms in office is an extension of the democratic character of a state. If we do not have adherence to these, this means that essentially we won't be counted as a democratic state, perhaps. We have 14 institutions currently operating beyond their term in office. And allow me to conclude on this note, something that we rather welcomed as a good piece of news. Beyond the horizontal rule of law mechanism, and beyond CVM, which was its predecessor, there is this problem that everyone identified, that the integrity of various institutions was compromised by the fact that the terms in offices were not being respected. And actually, this was put down in the report on the European semester. The European semester monitors indicators having to do with economics. It has to do, for instance, with the implementation of the Recovery and Resilience Plan of Bulgaria. So the report on the European semester in Bulgaria states the following. It states that the independence of regulatory bodies is questioned all the more due to the long periods of political instability. This means that a lot of institutions are currently operating under expired mandates. The recommendation was for Bulgaria to ensure greater transparency and quality of the work of regulatory bodies. We need to put our minds, heads together. Perhaps the people in the 50th National Assembly needs to do so and start acting. Bulgaria has an authority that is completely incapable of functioning currently. We have, for instance, the ombudsperson. We don't have an ombudsperson, we don't have their deputy. Basically, this is on autopilot, and the ombudsperson is supposed to be the people's defender. This is an authority whose composition can be selected by Parliament by regular majority, rather by simple majority. And this needs to be done because the next person who might end up taking office could be the next, the current interim Prime Minister. And with that, I'm stopping. Biljana has already handed Associate Professor Slavov the floor. You're currently here in your capacity as a former Minister of Justice. Currently, we're discussing issues pertaining to the judiciary. Many of them have been seen time and time again over the years. Before you became Minister of Justice, you co-authored the Anti-Corruption Fund's annual report when it comes to the work of the Anti-Corruption Commission. So I have the following question to you. How do you see the decisional practice of the Commission evolving, and how has this changed starting from the point at which you started observing this as a member of a civil organization? How have things changed since you took office as former Minister of Justice? Of course, the political environment of last year made making optimum or best decisions very difficult. Hello, everyone. I'd like to say that it's an honor for me to be here. I'd like to thank the Anti-Corruption Fund for their invitation. I'd like to congratulate you on your in-depth report. I'd like to congratulate the authors, the entire team of the organization. I'd like to thank the ACF's donors, because without their financial support, we wouldn't be able to, the civic sector would not be able to work as actively as it does now. And yes, I do need to wear different hats at events such as this one, so we'll see to what extent I'm able to do that. I'll start with a bit of a provocation for you. I believe that the title need not include freezing point. That sounds too pessimistic, I think. Perhaps a point of awakening. Why? Allow me to give you a positive, or rather optimistic spin on the report. One of the definitions of corruption has to do with arbitrariness in the exercise of power. 4 years ago, Bulgaria's civil society rose up against mass institutionalized practices of arbitrariness in the exercise of power on the part of the Prosecutor General and on the part of those in government. Where are we now, 4 years down the line? Well, there have been some changes implemented. It is both the reports of the ACF and other authoritative reports that show this. Some distance has been covered, but how did this happen? First, we did away with the Praetorian Guard that had been instituted to protect the Prosecutor General and to do whatever it wishes to protect them, the so-called Defense Bureau under the Ministry of Justice. Now, this structure aims at protecting citizens, which is what it's supposed to do. What else? One of the institutional tools used to implement punitive repression was the so-called system of specialized justice. It took a while. 3 national assemblies worked on that, and in 2022 it was done away with. And of course it was returned, and all of these cases were returned to the remit of general courts that deal with criminal cases. Has this led to a decrease in arbitrariness? I believe that thanks to the doing away of this tool for institutional arbitrariness, yes, it has. In 2020, the specialized justice institutions had allowed for mass surveillance of civil activists, journalists, political actors and others, and this was authorized precisely under the framework of specialized justice. These were surveyed on suspicion of crimes against the state, and all for because of the fact that they exercised their constitutional right to protest. Of course, this phenomenon has not been done away with. It has metastasized this, if you will, but it is less pronounced. That's because many of the people who handed down such decisions are now in the teams of general courts, and some joined the lists of people who wanted to investigate the Prosecutor General. So in case there are further cases that merit investigating the Prosecutor General, those people might end up being selected to do that. I don't know how we can safeguard against that. Another change that was duly noted in the report that did take place has to do with the mechanism to investigate the Prosecutor General. This has to do with amendments to the Judiciary Act and to criminal proceedings on the whole. This is long awaited. It was awaited by legal professionals, civic society, and our partners in the EU and the Council of Europe. Indeed, this is a change that got off to a bumpy start. And we'll see what fruit it will come to bear. This is a mechanism that was, by the by, constitutionalized, that is, it was enshrined in the constitution, so that it's thanks to challenges before the Constitutional Court, which it did not uphold. These amendments to legislation do mark some progress, regardless of all the well-argued criticism that has been leveled at the status quo. These three acts that have been amended or created were also underwent constitutional review. There were accusations of non-constitutionality. There was a member of parliament who said, "Do not lay a finger on organized crime because that would breed chaos."
So we hope that this new government that we're all expecting to see will bring some order in the case. What I mean to say is that some steps were taken. Maybe they were not as decisive as many of you wished, but some steps were taken. And of course, I should mention some developments that I had a say in. For example, the constitutional changes from last year and removal of office from Mr. Ivan Geshev. I completely agree. Actually, he was removed on political grounds. And what happened was the members of the Supreme Judicial Council who were dependent on politicians were influenced to take a decision to remove Mr. Office from power. At the same time, though, we all agree that Mr. Office should not have been appointed as Prosecutor General in the first place. Furthermore, two ministers of justice, Nadezhda Yordanova and Yanakis Tuilov, petitioned that Mr. Geshev is removed from office. Their arguments did not win over the members of the Supreme Judicial Council, but eventually, on other grounds, he was removed. But what happened in the Supreme Judicial Council in the end related to the removal of Mr. Geshev, we saw a process that did approximate something that we wish to see more of in the future. Because among the membership of the Supreme Judicial Council, we do have judges that had been appointed by their colleagues, participating in the decision-making. And we counted on those judges to issue a decision and to issue decisions that, that maintain the integrity of processes. So we were somewhat successful, and maybe the words of Mr. Geshev himself were also served to show this. Actually, Mr. Geshev himself told me, "Mr. Slavov, I did not expect that you would lead the session of the council in such an impartial manner." And for me, this was very important because we had to give the opportunity of the judges who were part of the council to provide their grounds for this decision. And their grounds were actually based on the law. So for me, as a citizen, as a legal professional, it's important to set standards and to set higher standards than the ones that institutions seem to be following at present. And now I'll say something that I haven't stated previously. So the hearing to remove Mr. Geshev from office lasted more than 2 hours. And at the 2-hour mark, I received a call from the National Assembly. Mr. Slavov, what happened? He should have been removed from office already. And I said, well, this is a process. We should follow the mechanism and the proper process. And so it took longer. It took about 24 hours. And Mr. Geshev was given all the opportunities to defend himself and to answer some of those accusations that he faced within the Supreme Judicial Council. Well, it's true that it was difficult and impossible to actually to defend his position, but we needed to have the proper mechanism for all of this. So allow me if I have digressed a little bit with all of this. But what I mean to say is that it is people who implement and who apply the law. So it's about selecting people who are able to act with integrity. And this ensures that legislation that has been passed is indeed implemented. So it's about how you shortlist candidates, how you vet them, and so on. And this is the step within which political players are completely failing. And I completely agree with what Biljana said about the strategic corruption at the highest levels in Bulgaria. Now, let me say a few words about the constitutional changes. I don't want to. I will still remain committed to this case. Yes, we made a lot of compromises to achieve some of those amendments to the Constitution, but I believe these amendments, despite the criticism, were actually sound in terms of the structure of the Supreme Judicial Council, in terms of the mechanism to oversee the powers of the Prosecutor General, mechanism for accountability of the prosecution. These are actually good amendments. How they will be implemented and what their effect will be on the ground, then it depends on all of us. My ambition for this year was to table a new law for a new judicial act, and which allows for those constitutional amendments to actually be represented in the new legal text and to be implemented. And I believe we were successful in doing this. And here I'd like to mention the civic sector, the Anti-Corruption Fund Foundation, the Right to Public Information organization, Mrs. Georova-Vegerceder's organization, and so on. Their contribution was very valuable. Maybe now is not the time to discuss the changes, the political changes that happened earlier and the dissolution of the government. But actually, I believe what led to this dissolution of the majority was the possibility that these new legislative changes to be actually implemented and to be working. And so when this possibility became real, then we saw that long-established political actors weren't willing to let go of their informal power. So some steps were taken, and of course the legislative initiatives should be implemented, and then the rules that ensure their adoption should also be adopted and implemented. But we as civil society should be watchdogs of this process. And we should not allow that politicians that we like or politicians that we dislike, to act in an arbitrary manner. I believe this is our mission as civil society. Thank you. I would like to just add something to what Dr. Slavov mentioned related to the constitutional amendments. And it referred to something that to an argument I was trying to make. So in terms of these constitutional amendments, making them work, actually implementing them in practice, it's related to the adoption of the Judicial Act. So these amendments to the Constitution actually set out a timeline for the adoption of other legal texts. And the timeline was 6 plus 3. So we calculated that until the 22nd of June, the Judicial Act should have been adopted. This would have allowed to observe another deadline of 3 months to elect the leadership of the Anti-Corruption Commission, the new Prosecutor General, and other important posts. And here I would like to mention the upcoming election of the leadership of the Supreme Administrative Court. I believe this was also one reason why, for the political turmoil and the dissolution of the government, because the key to these reforms is with magistrates, with the judicial system, and this probably is also a good transition to Judge Tsarigradska. It's about how this system functions and how magistrates are allowed to function within it. Thank you, Biljana. Thank you, Atanas. Precisely because the judicial system is so crucial, the efforts of the Anti-Corruption Fund Foundation and other civic organizations are focused precisely on the manner in which the judicial system functions. Because justice and the citizens' need for justice cannot be fulfilled without a working judicial system. The belief of individuals that in case their rights have been violated, there will be a judicial system that can defend those rights and that can be impartial, regardless of who has violated their rights, whether that actor has political power or financial resources. This is why our investigations, such as the 8 dwarfs, are so important, or the list of quick control, another investigation of ours. Within this investigation, we focused on a person called Martin Ivanov, the notary. He was not acting alone. He was supported by many institutions, by prosecutors, by officials from the Ministry of Interior and other public officials. We don't know the scope of his entire network, although we were able to show his network. And this person threatened a judge. And this brings me to the point how important civil society is and how important it is to have actors and individuals with integrity working within the judicial system. And with this, I would like to give the floor to Judge Tsarigradska. Judge Tsarigradska, it's a great honor for us to have you here today. Please, can you tell us from the point of view of a judge who has been threatened, who has been subjected to extortion, how did you manage to keep your integrity? You've been reporting to the prosecution that you were threatened, but the prosecution has not acted on these reports. What happened? And how do you believe these dependencies within the judicial system can be solved? We've mentioned, for example, the monopoly of the prosecution over the pretrial proceedings, and sometimes it even reaches the court stage. Of course, in violation of the laws of the Bulgarian law. But how do you view this topic? I give you the floor now. So I'm at a loss where to actually start. I wanted to comment on what Dr. Slavov said. I'll try to be brief because I believe many of you are tired already. I agree with Dr. Slavov that we did see some steps within the short period from 2022 onwards that were encouraging. And I also agree that the amendments to the Constitution, to the Judicial Act, to the Civil Procedure Code were positive steps. However, I will agree with the position of the Anti-Corruption Fund Foundation is that this is really a tentative step, and it cannot answer to what our society wishes to see, which is reform. Essentially, we need implementation of these amendments and a new mechanism of how, and for this to happen, it's about the culture, a change in the culture of magistrates, judges, prosecutors, and actually investigators in Bulgaria are still considered magistrates. The new Article 117.2 of the Bulgarian Constitution was something very important, because the first attempts to achieve this back in 2015 drew a reaction that is, for me, really illustrative. Back then, the Minister of Justice just said one thing when he resigned. This is not a parliamentary republic, this is a prosecution republic, prosecutor's republic. Back then, the attempt to amend the constitution along these lines actually failed. So right now, considering the situation at the moment in terms of the legal framework, considering the culture within the institutions, it seems that prosecutors have the upper hand compared to judges. And I believe this is a problem that goes outside of the borders of Bulgaria. We're seeing an erosion of democracy, not just in Bulgaria, but in other countries in Europe. And I have actually asked magistrates within Europe discuss this topic very often, and the topic related to the erosion of the rule of law in Europe. I was also very happy to hear that Mr. Yankulov mentioned the issue of pardon. When we talk about corruption, we usually look at it in monetary terms, in terms of, for example, the damages to the taxpayer. But for me, what's most concerning is how human rights, basic human rights, can be affected by some of these proceedings. And what worries me is that judges can be threatened, and all sorts of people can be threatened. Their rights can be infringed upon, and then nothing really happens as in terms of an institutional response. And for example, if we consider the Council of Europe, they place an utmost importance to the issue of the rule of law. Last year, Professor Kerstijk, who is a judge in the Netherlands, he gave a speech as he was appointed as a professor in the University of Maastricht. And he mentioned the culture of judges and the importance of having judges who are acting with integrity. So in this sense, the persona, the personhood of the judge is really important. So according to him, the rule of law is threatened throughout Europe because of the political and geopolitical compromises that Europe has to do in terms of defending the rule of law. For example, also by turning the other way when decisions of the European Court of Human Rights, for example, are not fully implemented. And in this regard, the role of judges is really important. For example, this topic has been touched upon by the European Court of Human Rights. In a situation where the rule of law is threatened, judges are actually obliged to talk about the threats to the rule of law. And this is, I'm quoting here a decision from 2022 of the European Court of Human Rights. So judges are obliged to actually react to these violations or threats. And this is, of course, in line with the ethical code that we have here in Bulgaria. According to this ethical code, all magistrates should inform not just institutions but also society when various actors try to threaten or pressure them in exercising their authority. Citizens should know what's happening in their in justice system and in the judicial system. In this regard, I would like to congratulate the ACF for their work. And specifically, I'd like to congratulate them for the fact that they're acting in a professional manner, in an ethical manner, but also actually acting very bravely. Why am I using bravery here? Well, because, and you will see from some examples that I will quote shortly, is that a lot of bravery is needed in Bulgaria to defend key principles of the rule of law and key normative principles. The reason why I'm worried, actually, it's not just me who's worried about the state of affairs of the rule of law in Bulgaria. This is an opinion shared by the European Association of Judges, the European Association of Administrative Judges, European magistrates, the networks of European magistrates. They called on the European Commission to monitor very closely rule of law in Bulgaria. They used several very specific cases which show what's happening as a result of this excessive powers of the prosecutor general. And here the examples are concerning Judge Luzampanov and the attempts to pressure him. You remember that he was being welcomed at the entrance of the Supreme He was being welcomed by his place of office with the cut-off animal parts as a sort of pressure, as a way of threatening him. And here I'd like to mention other judges who were being pressured, who were being the subject of surveillance. For example, Judge Lazarov here. Judge Lazarov, there was an investigation by the prosecutors against Judge Lazarov for trying to actually do his to do his job. And of course, here some of you know my case, and I'm not mentioning it just because it's my case, but because it really shows you what's happening in Bulgaria right now.
Mr. Bozhanov was shot, and this was yet another case of a person being shot who may have been involved in underground activities. 3 people have been shot before him. And I mentioned to the colleagues at the SJC about what has been happening to me ever since I told my story. They told me that for a number of months I would have to remain under security. The various threats had not been investigated. I tried to give my experience, adduce publicly available data to show how judges end up being subjugated. There are specific ways of attacking them. The Judges' Council had a report that stipulated that in a particular number of years, about over 100 judges were subject to such threats. We don't have a specific analysis of these. I tried to explain to the current prosecutor general, etc., that the media are often used to act against such judges who won't fall in line. I said that the use of these media shows a lot of dependencies. And these have to do with high-profile cases, such as, for instance, the KTB case. And then there are cases of attacks on judges. Lastly, we had the use of specialized surveillance means. And after I shared my story, the systematic threats started being sent to colleagues and to me. I was threatened that I would be sadistically killed, and the same went for my family, and so on and so forth. With that, I'm trying to show how important it is for all of society, but to Europe at large, to see who the people who form part of such influence circles are. I'm talking about the notary circle and the eight dwarfs circle. There is enough public information pointing to links between the previous and the current prosecutor general with each of these groups. Indeed. Only bringing this to public knowledge can we build up public immunity, so to speak, against these. The Judges' Council, on whose management board I sit, called on the 50th National Assembly to reinstate the temporary commission set up by the 49th National Assembly to investigate the work of Martin Bujanov, the notary. We expect that such a line of work should continue under the special committee with the Supreme Judicial Council. It does encounter difficulties, however, collecting information, particularly where cooperation on the part of the prosecution is concerned. And to end on a positive note, the freezing point that's been mentioned and the lack of outcomes in these cases that have been analyzed is not too terrible, at least not in my view. Indeed, these are ruthless cases of inaction brought about by corruption grounds. But these clearly show, even to those who are not so observant and don't follow all these processes, they show them where the issue is actually rooted. So I imagine that next year, I would suggest that the title of your report should be Breaking Point. I have reasonable and I believe democratic expectation that the Prosecutor General will be present. They'll be able to share their opinion, share their, and perhaps they'll be able to show what their opinion is like today. I hope that he will have some ideas on why, on how the institution that he's heading can be reformed. Thank you, and I'm sorry that I've gone over time. Thank you very much, Judge Tsagratska. We do call the Prosecutor General to each of our presentations, but apparently he has other priorities such as combating corruption, who knows. Now, I open the floor for questions. If you have any questions to the panelists, of course you can ask your questions in the room next door, where you'll be able to also grab a bite. You'll just need a microphone, so wait a while. Unfortunately, the interpreters cannot hear the speaker's microphone. Thank you. My name is Nikolai Nedelchev, and I have the following question. When it comes to the ad hoc prosecutor, that we've been expecting for so long. The Kolevi decision hadn't been implemented for 15 years. Of course, it's not all about this particular issue. This is just the tip of the iceberg. There have been several case files created by the ad hoc prosecutor, but then they have discontinued said case files and refused to bring proceedings before a court. I don't know what the court stipulates about these case files. Can they be appealed? If so, when? And whether they should be made public. And then the ad hoc prosecutor, Ms. Peneva, stated in minutes before the prosecutor chamber of the SJC that the case file, as regards the 8 dwarfs, was due to be closed. What does that mean? Does that mean that all of it is settled? There were video evidence, audio evidence, witness testimony, and so on and so forth. So how would you interpret those minutes that cite that? Andrey, perhaps the question is most likely to you. I don't know if it is exactly to me. Indeed, there is judicial review that has been envisaged. That is the decision by the prosecutor to not proceed with the court stage can be appealed. It doesn't have to be published. There is no obligation for decisions by prosecutors to be published. According to the Judiciary Act, there is a provision on the publicity of acts handed down by courts. Unfortunately, courts rarely follow this. When it comes to the reasons why court proceedings have not been brought, when it comes to these case files, we cannot comment much. We don't have information because the case files have not been published. We don't have enough information to form conclusions on that. Perhaps this new legal institution of national criminal procedural law will start being implemented well. As regards the 8 dwarfs case and how this might unfurl, this is our 57th case. We have explained how it has developed in this blue and white book that you have before you. Of course, we have the development up to this point. We don't know what conclusions the ad hoc prosecutor will arrive at as regards this, because we don't know what information the ad hoc prosecutor bases her conclusions on. Indeed, criminal proceedings by the Sofia City public prosecution did entail interrogations on the part of the prosecution of witnesses who stated that Bohuslav Sarahov does have some links with Petru Evrutu. But according to the ad hoc prosecutor, these witnesses changed their testimony following the reshuffling of the top tier of the prosecution. So we have some verbal evidence that goes both ways. It's not clear. We don't know whether the rest of the evidence has not been compromised, what its content is. This evidence that will have been confiscated when searching Evrutu's property, evidence that had to wait to be processed until the ad hoc prosecutor was appointed, and that was transferred to the Sofia City prosecutor's office. This evidence has a specific state. We don't know what it is. We don't know what the verbal evidence can point to. And I can tell you what the outcome will be. The investigative work will be discontinued. It might be in 3 months, it might be in several, it might be longer. It doesn't matter. For such proceedings to run, and for work to meet the high standard of proof on the criminal proceedings, a lot of work is needed. It's not as simple as it might seem. A lot of work goes into making a strong case that can be brought to court and meet the high standard of proof under Bulgarian criminal legislation. And then you have all the objective and subjective obstacles that put a spoke in the wheel of this mechanism. So the practical outcome of the implementation of this mechanism will not be too great, probably. Let's not fool ourselves. It is a good thing that it has been created. That cannot be denied. The good thing is that this is a check of sorts, a control mechanism, a lever that serves to constrain the otherwise huge authority the Prosecutor General wields. But if anyone believes that the creation of this mechanism will suddenly lead to the ad hoc prosecutor or rather to the Prosecutor General either being convicted or making it to jail in the next month or further down the line, let's not fool ourselves. We have a specific environment in which everything is set in Bulgaria. Elena, indeed, Andrey, the problem with this mechanism is similar to the problem with other things provided in Bulgarian legislation. The drafting might be great, but the implementation might suffer. So, indeed, it is very important for the people that are in the top tier of various institutions to be very characterized by great integrity. This could be a reason for early elections. Further questions, please.
Thank you for all the panelists for expressing your very interesting opinions. My name is Vladislav Velichkov, Justice for All, civic organization. I really like your title because, yes, everything reached a freezing point. And we don't know how long this period will last. However, I believe the constitutional reforms will not have any foreseeable impact. And we heard already the problem with the terms of office. Mr. Sarafov, who's supposed to be acting Prosecutor General, may serve on for another 2 years. The same applies to the Supreme Judicial Council and so on. So I used to argue with Dr. Slavov, for example, about some of these amendments that the government tabled and adopted. And I believe it will be hard to actually implement them. I believe also what Biljana said was very valuable. The governing majority dissolved because of a desire to thwart these attempts at reform. But my question is, couldn't you have foreseen those problems? Mr. Hristo Ivanov gave an interview recently, and he said that Delian Peevski from the MRF party had stated already in February that they will be the ones drafting the Judiciary Act. So wasn't this an indication already that the governing majority was about to dissolve? And my question is, why did you make such compromises to achieve these constitutional reforms? Why did you have to completely revise and rewrite the Judicial Act? Couldn't you have found other legal means of implementing these reforms and to start actually the change in leadership within the prosecution and the Supreme Judicial Council? Because this delay was really impacted very seriously the attempts to reform the judicial system. My second question concerns the Commission for the Countering of Corruption. And I have asked this question repeatedly of MPs representing democratic Bulgaria, and we continue the change. Why didn't you try to change Mr. Anton Slavchev, the right-hand man of Sutir Tsatserov, in power for 2 years? Why didn't you demand that persons like these, related to questionable actors, exit these institutions before actually amending the constitution and adopting legislative changes? So this is why everything reached the freezing point, because actually the people who are the problem were not replaced and changed. Yes, we see some good steps were taken to amend the constitution, some legislative steps, but those steps will not be implemented anytime soon, and they actually benefit the malign actors. And maybe it's good that these amendments will not be implemented, because if a new majority is formed in the National Assembly, they can really put people in place of those public organizations that make the fight against corruption even more difficult. So, can we find a way for a civic mechanism to ensure that the leadership in charge of the regulatory bodies will not be changed in an arbitrary manner? Some of the constitutional changes were already not accepted by the Constitutional Court. And there is a risk some of your other reform steps have the same fate. But I believe that if there are other attempts to change the constitution, some malign actors can now actually use the opportunity to make the situation even worse. Thank you, Mr. Belichkov, for the question. Personally, I think that to change the legislation, you need political will, and also you need a majority in the National Assembly. And the same goes with the leadership of different regulatory bodies. But with this, I give the floor to Dr. Slavov, who may want to add a few more words. So, yes, you know that there's a rule in politics. And, of course, this pertains to democratic politics. Decisions are adopted by a majority. The political party that I represent if we had had a full majority or a working majority in the parliament, perhaps the situation would have looked differently. But I do believe that the steps that we took and the amendments that we implemented will have a positive impact. So, in terms of what we would like to achieve is an impartial court and accountable prosecution. And you have independent and impartial court by having a judges quota in the Supreme Judicial Council. And within the prosecutors collegium within the Supreme Judicial Council, you have also a parliamentary quota there to ensure that they're accountable. I'm not sure what will happen in terms of the membership of this body, the Supreme Judicial Council. Of course, what we see is that the political situation did affect these bodies, this body, following the dissolution of the majority, the governing majority. What happened is prosecutors from all over Bulgaria started writing letters against the constitutional amendments. So it seems every minute changes in the political environment cause the status quo to go on the offensive and to try to reclaim the judicial system and to return it to the state that it was before the measures that we took. You know, in the ministry, we tried to adhere to all of the promises we had made to implement changes to the Judicial Act in June, to ensure that the leadership in some of these key bodies is elected as per the new procedures. We had deadlines, and these were the deadlines that I was referring to, all of the meetings with our partners, with the representatives of the diplomatic corps, and we did this in good faith. Of course, when it comes to some of the decisions that were taken, I wasn't the person involved in terms of the informal decisions. I give the floor now to one last question, following which we can just continue an informal discussion in the hall next door. My name is Dimitar Petsov. I'm an activist and journalist from the town of Silistra. I focus and I try to highlight corruption at the local level. And my question is, do you know what's happening with the work of the anti-corruption bodies at the local level? I know you're preparing a report later this year, but is there anything you can share about the anti-corruption work at the local level? I know the Anti-Corruption Commission does review some conflict of interest cases and corruption cases that pertain to the local level, but do you have the bigger picture? Thank you for the question. Yes, we are currently analyzing the work of the local anti-corruption bodies. From what we have seen so far, the situation is not optimistic. Those bodies have received a lot of referrals, but they have reviewed very few cases, and this has happened throughout. And this refers to the local governments that have shared information with us, because some haven't. Actually, within the booklet, there is a small part which deals with the issue that you mentioned, considering anti-corruption efforts at the local level, some investigations against mayors, for example, and so on. And I didn't touch upon this subject because the picture there is not different than the overall picture at the state level. Let me just say one more thing about local governments. We've issued recommendations, and we keep on issuing these recommendations in all of our reports. There is one recommendation pertaining to the Act on Local Government, and this is related to municipal councillors. There is a text which states that when they vote on municipal budgets, they are not exercising, or they're not in a hypothesis of conflict of interest. We believe the wording of the law is very weak, and this should be resolved. Thank you, Daniela. With this, I end this discussion, at least its official part. I would like to thank all of the participants, all of the panelists, and now we're happy to welcome you for a cocktail reception. Thank you.